Great. Thank you, everybody. Thanks for joining. I'm Sarah. I'm a partner at Freshfields, where I work with lots of companies that are pre-IPO and thinking about going public, and those that are already public. I've got a treat for you today with a great panel. I'm delighted to welcome all of them, but I'll start with our man, Rob, in the middle. Rob served as an SEC commissioner during the Trump administration from 2018 to 2020. During his tenure, he was an outspoken advocate for protecting investors, consistently calling for more transparency in capital markets and championing data-driven policymaking. Do you take that?
Sure.
Yes, great.
I've been called a lot worse.
He also previously served in the Treasury Department. I don't know if any of you remember TARP, but he's very involved with TARP. And is a law professor, as I think you're going to see on the panel today, as he uses the Socratic method on the rest of us. He's also in a prior life practice at Wachtell. He also is taking on an extra duty today. Unfortunately, Commissioner Allison Lee was not able to make it, so he'll be both channeling her and offering his own views. And so we're going to follow our original format, in that we'll talk about a speech Commissioner Lee made a few months ago, where she focused on what she called the dark market. And her concern was around companies that are staying private for a very long time and that are really too significant to be private, in her view. And then from there, we'll go to our other panelists, and I'm going to have them each introduce themselves now, starting with Jen.
Hi.
Let's make sure Jen's mic'd. Try again.
Hi. Hi, everybody. My name is Jennifer Ye. I'm general counsel at Checkr. We're a late-stage background check company. We leverage technology and machine learning to create more efficient, compliant, and accurate background checks. We're known primarily for serving the gig economy, and we also are a big advocate of fair chance hiring.
Over to you, Adam.
Great. Hey, everyone. My name is Adam Eltoukhy. I'm the general counsel at Samsara. We're an IoT company, Internet of Things company, that focuses on physical operations, increasing the safety, sustainability, and efficiency of folks in the physical operations space. That includes industrial, commercial, transportation, warehousing, basically anyone that moves things or people or places. So nice to meet you all.
And you guys went public?
We just went public in December.
Awesome. Scott?
Hi, everyone. Scott James. I'm the general counsel at DCVC. We're an early stage venture capital fund based here in the Bay Area, offices in Palo Alto and San Francisco.
Great. So Rob, if you would, we'd love to hear just a brief outline, I guess, of Commissioner Lee's thoughts on why she thinks these private companies should be forced to go public earlier, or at least should become reporting companies earlier.
Sure. So first of all, thanks so much for having me. I'm so glad to be back at the Berkeley Forum. I was here a few years ago when I was in office as an SEC commissioner, where I gave a speech about the regulation of dual-class stock. It was a super popular speech.
I remember it.
Yeah, I got booed out of the place. Actually, one reason I love the forum so much is that it really is a place for an exchange of ideas. And I hope you took, I think you, many of the audience did take that speech as an offering of some ideas about what the future looks like in capital markets. And if you want to know what the future looks like, this is the forum to come to. So that's why I'm here and why I wanted to bring my friend and my colleague, Allison Lee. Unfortunately, she wasn't feeling well today. So you're kind of stuck with me. Sorry about that. We're going to talk a little bit about a speech that she gave a few months back that highlights a concern that she's had for a long time now, since she was acting chair of the commission during the interregnum before Gary Gensler took over the agency. And the concern has to do with the size of private firms. And what Commissioner Lee points out in this speech, and I think we can all agree, that over the last 20 or 30 years, the world in private capital markets has changed quite substantially. Before I was a law professor or even a lawyer, I was an investment banker at Bear Stearns. Not my fault. I didn't do that, but I did IPOs at Bear Stearns in the late 90s. I was out here in San Francisco, and I raised a fair bit of money. And at that time, if you wanted to raise $800–900 million, $1 billion, you had to ring the bell in New York. That was a hard number to raise privately. Now you can make a wrong turn on Sand Hill Road and raise that kind of money. And I'm not here to tell you that that's bad news. That's not where the Commissioner Lee's speech starts, and that's not my premise either. I'm just describing a fact about something that's changed in the world, which is that private capital markets allow firms to get much bigger before they go public. Identifying this in her speech, Commissioner Lee raises the concern that I think there's a twofold concern described in the speech. First, that companies that touch a lot of Americans' lives and that are changing the world around us aren't public. And that deprives us of some information about their finances and operations and choices that would be good for the public to have. And second, she points out, many economists over the years have argued that public disclosure provides a positive externality to society. Competitors learn about the practices of a firm. They can refine and challenge existing approaches to customer service products and the like. That's a healthy thing for the economy, and that public disclosure provides this externality, and we should want more public firms for this reason. Therefore, Commissioner Lee suggests we should examine whether or not companies that are large and private should be nudged to go public, either by the number of beneficial owners they have under the securities laws, by restricting that number in a way that would force many private firms to go public, or simply by coming to the conclusion that the securities laws compel firms at some size, some scale, some import to society to become publicly regulated, publicly traded firms. And she raises this, in my view, as a series of questions to ask about the increasing scale of private firms. I'm going to offer one more thought for you all, which is that another aspect of the IPO process that I remember from my days as a banker is that a firm that is very large and has managed to achieve lots of scale can put lots of pressure on public markets and investors with respect, for example, to its governance choices or to other choices it makes about being public. So, take, for example, Facebook. Facebook goes public, it's giant, and it's the only game in town. It's not like when I IPO'd Webvan and there were 3 of them and they all went bankrupt.
I worked on one of the other ones.
Sorry, that didn't work out. Yeah, but it's not like that. There's one Facebook, take it or leave it. And it's dual class, by the way, forever. And by the way, Mark's kids can inherit the control, take it or leave it. And you might hope that in the markets that we have, maybe stock exchanges would play a role in saying, well, there's some limit on the governance things you could do. I tried to say that with a straight face, but couldn't get to the end of the sentence because that's not what stock exchanges do anymore. They're not in that business. Instead, when Adam wants to take WeWork public, it turns out like we didn't know what we was. What? Anyway, we didn't know what we was. But the New York Stock Exchange didn't ask. Instead, they changed the food in the cafeteria to try to get Adam Newman a list there because that's what they do. And that's cool. But we can't expect them to play this meaningful intermediary role. Therefore, if we let firms get very big, we will see changes in public company governance that might worry us, like a move toward something like perpetual dual class, and you know how I feel about that. So I'm adding my last thought there just as something else we can discuss if you're so inclined.
Yeah, no, thank you. That's perfect. So what we're going to do now is focus on 4 questions over the next however much time we have. First thing we'll talk about is when is the right time to go public? Then, should the SEC be forcing companies to go public earlier than they might want to? Is the number of shareholders the right metric for forcing an IPO? And is there really something wrong with letting a company stay private? So here's a question for the audience. Raise your hand if you think investors would be better off if Silicon Valley companies, or really any private companies, would be forced to go public earlier in their life cycles. Or I guess I should be more neutral and say, do you think the world would be better off if IPO timelines were accelerated? Raise your hand if you want to see this acceleration. Not very many people saying yes. Okay, well, let's hear from our panel on this. So you're in the boardroom with your management team, and you're talking about when is the right time for your company to go public. What do you focus on? I don't think it's your number of shareholders. So what is driving your decision?
Yeah, I think part of this discussion assumes that companies don't want to go public. Most companies aren't Facebook. So my company, we want to go public, but we want to make sure we're in the right position. So for a lot of it, it's financial predictability. It's having the right team in place. I know for a lot of tech companies like mine, you're investing in R&D and in innovation in the first few years. So you're not really investing in the G&A functions like legal and finance that you really need in order to go public. So it's not a matter of we don't want to, it's just that with limited resources, we just haven't gotten to the point where we're ready to be able to go public.
Any other reason?
Yeah, I think when you kind of go through the process, the different categories that people mention are like publicity, right? You want to get more acclaim amongst your employees, amongst customer base. There's capital needs, there's liquidity needs that either your investors have or that your employees have. And then there's this other component, which is like the forecasting that I think Jen is really alluding to. And I think that's the part that I would be the most concerned around being prescriptive about, right? The last thing you ever want to do is not have any of that stuff ready so that when you go out, you're not able to meet your forecast and not able to meet your numbers that you have out there. I think this kind of plays in a lot of different ways through making sure you have the right compliance framework, making sure you have the right sales motion, making sure you have the right product fit. Sometimes that takes a while, and it's not at all associated with the number of shareholders one has. I think it's also, when you kind of think about what's the reason behind this, is to protect investors, is to protect employees. Something that's kind of interesting with this is, usually when you're transitioning from private to public, what I found at least is that the company is actually restricting more access to information to employees, right? So in the private space, you often have founders that are radical transparency, right? Like show the boardroom slides, show the forecast information, employees know everything.
It gives people like me a heartburn.
And when you're transitioning to public, it's the opposite. It's like the average employee before you go public knows way more information about the company than they do post. So I think it is really important to focus on who are we trying to protect and why, because I think that kind of figures that helps you figure out which is the right instrument to solve it.
Yeah, I mean, did you want to say something?
No, go ahead.
Sorry, I mean, I think it's a good segue into the second question, which is, should the SEC really be forcing companies to accelerate their IPO timeline? And she focused on a number of things. And interestingly, she focused on this, what I'll call a macro reason, that it's just too important to the rest of the world for these large companies. We need to shine light on them, essentially. And she talks about how they're changing the economy, the way we work, who we hire, how we hire them, how we get around town, how we shop, how we pay for things, how we invest, what we invest in, how we relax. All of these things are worrying, it seems, in her speech. And so I think the question is, first for the audience, again, because I know we're getting closer to cocktails, do you think the SEC should be focusing on those, I'll call macro issues, before enforcing companies to go public? Same two people. Wow, thank you. Oh, there's a third over there.
So I just want to be sure I just understand the question. So I read the speech on the companies in the concerns you're describing to be focused on the very largest companies. So Facebook would be an example, maybe.
The FOMO one.
Right, that's right. Not Checkr, I think, yet?
No, definitely not us.
I mean, it's kind of a tough question because I'm from a business side, you'd love, but maybe not regular. Anyway, so to me, I just want to be sure we get the audience's view right. It seems to me the question is, for those firms, for those sort of macro, to borrow your phrase,
okay,
firms, do we think the SEC should be concerned about not having information about them?
Who agrees with that? Same two people? Any more? Tough crowd. Let's get your views on this, Jen, because we talked about this before. Is this a good enough reason to force a company to go public?
I mean, I think it's absolutely important for there to be regulatory scrutiny and oversight over companies that are transforming the way that we live our lives. But I think that it's not necessarily the SEC's role to force that disclosure or oversight. For a lot of these companies that we've talked about, they already are being regulated, and there is oversight, a lot at the state level, a lot at the federal level. And so it's really about which is the appropriate regulatory body or governing body to actually exercise that authority. And when we're talking about things like when we're talking about the way that people work, the way that people commute or travel, I'm not sure that it's the SEC's role to enforce disclosure oversight over those bodies. And just speaking from Checkr's point of view, so we actually are a regulated body. We're regulated under the Fair Credit Reporting Act. We have the CFPB, we have the FTC, we have state authorities who exercise oversight over us. And that's appropriate because we touch consumer data. And I think that's the appropriate bodies to be overseeing what we're doing.
Anyone want to take a contrarian view? All right, so
I will. So to borrow the law professor's phrase, that argument proves too much. If it were the case that the SEC doesn't oversee things where other regulatory bodies are involved, they wouldn't oversee the mining industry or securities issued in the mining industry or the banking industry. It's of course not mutually exclusive to have a company subject to regulatory oversight and SEC scrutiny, so I'm not sure that provides a compelling answer. I do think there's another possibility here, and Allison's speech mentions it, just to be fair to the speech and to the commissioner. One argument could be, to the degree these concerns exist, they shouldn't be resolved by the SEC, but instead by the Congress. The Congress has made a choice, arbitrary be it that it may be, that is that if you issue securities under these circumstances, you can be subject to public disclosure. If you don't, you can't. And if we want to change that, that should be a subject for Congress. The evidence about the Ubers and Facebooks and the exchanges and such would be better put in front of the Congress than the SEC. That, I think, might be an argument that gets a little more traction, both in front of the current commission and more generally. But I don't think we should say or think that just because a company is subject to other regulatory oversight, the SEC shouldn't provide transparency. It just doesn't follow.
Fair enough.
But I also think it just goes with, again, what's the reason that we are doing this, right? Is the reason because we want to regulate or require disclosure for companies that are having a really large effect on the economy, or is it to protect investors and employees? Those are two very different questions.
It could be both, though, right?
It could be, but there are different instruments that you use to get, depending on which one it is. I think if it's investors and it's employee base, there are a lot of rules out there. There's Rule 701, there's other disclosures. There's, in late stage private offerings, you negotiate, right? Like institutional investors, mutual funds, they have a lot of leverage in some situations, particularly if you're a late stage private company trying to go public and you're trying to get those crossover funds or those institutional investors. So I only bring it up because again, the reason why to me suggests a path to get there.
I want to follow up on, go ahead.
I was gonna throw in there too, is I think there's this, simple recognition too, that there's no forcing a company to go public. There's a lot of people involved in those decisions, bankers, lawyers, executives, investors. And to kind of think about it in that simplistic of a way that somehow you have these larger concerns, which I think people will nod their heads to, of more disclosure, a good thing, these are big, impactful companies. In all the ways that could maybe go wrong are, seemingly like pretty reasonable concepts, but then translating it to some of the specifics about shareholder count and then, trying to push people to be public sooner than they want to. I just don't see the connection as much. And pushing companies to be public sooner than they're ready, I think has a lot of costs, some which we could probably identify, others which are hard to predict until it happens, that I'm not sure like the cost benefit there really makes sense, especially with such a crude instrument like shareholder count, which is complicated for a lot of different reasons.
I just want to be clear, that instrument is one that Congress has chosen. I don't think it was Allison Lee who was.
No, that is true.
And I, by the way, I want to fully agree with you. It is an arbitrary number. And I don't think it makes sense to distinguish on that basis. I also don't think anyone's talking about forcing companies to go public. Neither did we in the 90s when you had to go public to raise $1 billion. We just said if you want to get to this scale of capital, you're probably going to have to tap public markets. And I think that would be the arrangement that Allison might be imagining.
It's true, but what happens is if you're going to hit that threshold and start having to report, then you might as well do your IPO at that point, right?
Sure. And that's a choice companies have.
Well, I think it'd be good to hear from Adam on that, because your company went public in December of 2021, probably the last company before everything fell apart. And, you were thinking about going public, I think, in early 2020. Very different time frame, very different things going on at those times. What if you had crossed the threshold earlier and had to go out and say April 2020? How do you feel about that?
Yeah, I think this is one where it's like you talk to a lot of private companies and how far out are you? It's always 18 months, right? 18 months are going out. You don't really know until you kind of get into the trenches of what's happening to figure out what your timeline is. And for me, I've been at two companies that actually both IPO'd and DPO'd over the past 5 years. And in both situations, the timing was very much impacted by more macro level issues other than shareholder count, right? And my first company, it was far more about getting a repeatable sales motion, getting that product fit, getting that forecastability. At Samsara, we have a hardware component that was very much dependent upon COVID, dependent upon supply chain issues. And the last thing we wanted to do was go out, miss our numbers in the first 2 quarters, and then have our stock price tank. Now, I don't really see how that could be good for the average investor either, right? When we're trying to build that credibility with investors generally, like that first year that you're doing it, you really need to make sure you're being accurate. If you don't feel confident that you're going to do that, it's really hard to kind of make that bet.
Absolutely. Scott, in your role as a GC of a venture fund, sorry, my watch, hold on, okay. You see so many companies, right? How do you think about this. Is this helpful that the SEC is pushing your companies potentially to be public earlier? I mean, that should be good for you, right? You want liquidity as a VC?
I mean, in a perfect world, liquidity is a great thing. We love IPOs. That's kind of the ultimate outcome from an investment standpoint. But having the view of a portfolio of companies at different stages of the journey, from super early to late stage pre-IPO, you realize just how fickle that journey is, and that predictability and sales forecasting sounds simple, but it's a really tricky thing, and you want companies really prioritizing that growth and that technological process and hiring people and doing all these things that we think are really important parts of the economy, and making that strategic decision when it is time to open up to more scrutiny, more disclosures. And from our perspective, the longer term view is we want great companies to go public because that creates durable, public company value, which allows us to distribute highly valued securities to our limited partners, and that's a good thing for a lot of different reasons. It's kind of interesting to think about in contrast to the last 12, 18 months of the SPAC journey, which has kind of been this, strange adventure we've all been on of pushing companies that weren't ready to go public frequently out to being public, because guess what? They could give, revenue forecasts and growth projections, which, told the story that a lot of us here on the private financing side. From an investor standpoint, the SPACs haven't proven to be some big, exciting, everyone's, high-fiving each other because of complexities around liquidity, how the market is traded. And that's just an interesting example to see these less mature companies finding some regulatory arbitrage to get public. And I don't know if that looks like a good sample set to, try and strive towards.
Do you want to comment on this, Robert?
I think these are really important points. And having done IPOs on the business side, I think the risk of nudging companies to go public that aren't ready are very high. And I think the data show that over an extended period of time. I just want to be clear, just again, to channel Allison, who couldn't be here. I don't think that's what she's proposing. I don't think anyone's proposing to make unready smaller companies that aren't ready to go public. I think we're talking about very, very large employers of tens or sometimes more, thousands of people. I think those are the companies that are the focus. We can debate whether or not nudging Facebook to go public before 2012 would have been a good idea, but I don't think she has in mind immature VC level companies that you'd worry about going public too soon. And by the way, let me just say that I'm so glad that you've made this point, because one of the things I think Allison's responding to in the speech is an argument that gets made a lot in Washington, although I rarely hear it here, because you guys are on the business side and you know that it's dumb. The argument is that companies want to go public. They would go public. It's just too expensive to go public. Like, there's lots of boardrooms that are like, let's get like liquidity and merger currency and like the legitimacy of ringing the bell. But you know what? The registration statement has to be 10 extra pages. So no, let's not do that. Like, that's a board meeting I've never been to. But in Washington, that's an argument you get a lot. Like, people will say, well, if we only made things easier, more companies would go public. Like, that would be a good thing. And I had to answer questions like all the time. I had this meeting 3 times a week. Like, hey, why don't you lower the cost? What about freedom? Let more companies go public. And I'm like, I don't understand, because what history teaches is that if I relax those requirements, there'll be more fraud. There's more fraud, ex ante, investors will raise the cost of capital, and you'll get less long-run positive investment that's bad for the market, bad for everybody. What about that counter-argument? And they just be like, wait, didn't you go to the workshop where we all say this? Like, I missed that meeting. So I think part of what Allison's responding to is this notion that it's necessarily problematic or a bad thing to have a company go public and be subject to the public disclosure regime. The thinking is, no, that's not all costly and bad. And I think that might be part of what she's responding to. And the point you're making, which is very well taken, is taking companies public early can be problematic. And it's a point that I think isn't made enough in policy circles.
People worry a lot about the quarter-to-quarter pressures. They worry too, many of the companies, as Jen knows very well in the Bay Area, are very mission-focused. They have, of course, they're for-profit enterprises, but they also are focused on a mission, and it can be much harder to stick to that mission once you're public. So I think it'd be good to hear from you, Jen, your perspective on that and what that would mean for your company.
Yeah, so as I mentioned, Checkr, we're a big advocate of fair chance hiring. We incorporate it into our product. We also advocate it with our customers, but we also
Say what it is.
Oh,
so
fair
everybody
chance
can know.
hiring means, I mean, as ironic as it is being a background check company, we're actually trying to encourage employers to hire people with criminal records, helping them understand things about whether it's applicable or relevant to what they're hiring for, but also implementing tools on our product to make sure that things that aren't relevant end up getting either hidden or filtered out. So that's on the business side. But we also have like just our mission product, which is not revenue generating. We do things that automate expungements. And this is a really laborious process that we're doing because this is something that we really care about and our employees care about. So if we were forced to go public earlier or forced to really focus on just like financial profitability, this is something we probably have to forego. And I think a lot of companies in this space, they have this mission component that is a big part of why they are what they are. And so being able to focus on that early, in the early stages, is really important.
And many companies, mission-based companies, are thinking about the Public Benefit Corporation form, which is a Delaware form for for-profit companies, which that's a whole other topic for another day. But even those companies are subject to activists, unless, of course, there's a controlling founder with dual class stock, and that's probably another panel too. That would be really interesting. But I think people are worried about the quarter-to-quarter fluctuations and activists and losing their ability to really accomplish what they hope for their companies. So maybe there I'll transition to this focus. Necessary focus by Commissioner Lee on the number of shareholders. Necessary because that's what exists today. This is the so-called 500 shareholder rule for those of you who are as old as me, but it actually changed a few years ago to the 2,000 shareholder rule, except 500 holders, and then with another who are unsophisticated, and then a really major exception, and that is you do not have to count people that get shares through employee benefit plans, which basically means 12G isn't really a thing anymore that companies have to worry about. There's also an asset threshold, but it is tiny. It's $10 million, and that's after the rule change a few years ago. It used to be 5. So the question for the audience is, do you think, raise your hand if you think this shareholder focus is the right one. Ethan? No? Not this one? Okay. No one thinks it's the right one, or at least I don't think it is. Well, I guess we should talk about it for a little bit. How does this work? Do you want to draw this out, Scott?
Sure. I mean, I think it's obviously the rule on the books, so we're dealing with what we've got. But I think kind of using this as the method to maybe address some of the issues that we've talked about is particularly tricky because I don't think it really solves anything. If you think about this idea of counting beneficial owners, investment funds, venture capital fund, may have tens, hundreds, many more limited partners. And, using that as a proxy for some level of importance or sophistication of the underlying company, the impact it might have on the economy, reasons why disclosures are viewed to be positive. It just doesn't really tell you much. If you raised $1 million from a fund that has 1,000 people that they crowdfunded that capital from, somehow that company is disadvantaged as compared to someone who raised capital with a single investor just based on this kind of arbitrary test. So with the issues that I think are raised in the commissioner's speech, which are very much worthy of discussion given all the stuff that's going on, feels like this is maybe the low-hanging fruit just given kind of the parameters around how it could be changed without other action. But it feels particularly disconnected from solving anything of substance that maybe feels like what we're all concerned with, given that it doesn't really tell you much about the company itself.
And I guess it would be a reason for, I guess everybody knows this, but just to make sure it's understood, it's a competitive market out there if you're an investor, right? And it's hard to get in on the big deals. And if you have raised money from too many people and you'll be disadvantaged, that doesn't seem like a good thing either, because a company who's well advised will know not to pick you as an investor. So it just seems to have unintended consequences, and also seems to go against the SEC's mission of letting little guys get in on some of these gains that are made in these companies that have stayed private for so long.
Wait, sorry, what part of the SEC's mission?
What's that?
What was that last bit about the SEC's mission?
Well, I think there's a movement to let people participate in the gains that are being enjoyed by pre-IPO investors.
I see. So that's one of those things that I heard a lot, but I always was puzzled about because I went to business school before I went to law school, for which I'll never be fully forgiven, I think. Here's why I say that. So it's an iron law of finance that as returns rise, so does, what's that other thing? Risk. Oh yeah. So I don't know actually that what I want as a policy matter is to expose people to the kinds of under-diversified risks that exist in pre-IPO companies. First. Second, if I were gonna do it, I wouldn't do it by letting them pick individual companies. That sounds like a bad plan. Instead, what I would do is what the market already does, which is to allow mutual funds to invest on a pre-IPO basis in many of those companies on a diversified basis. So the reason I'm pushing back is that, by the way, I don't think the shareholder, the beneficial owner limit is the right way to go. I think 12G is not the path here. I remember it being a binding constraint. I'm glad it's not anymore. I think Allison picked it because it's what Congress picked it. I have ideas about what might be a better metric. But I think we should be careful about something like wanting to be more inclusive about opportunities to invest in pre-IPO companies. I'm for it. But I think we should be wary of the fact that it's just an iron law of finance that people who invest on that basis are exposed to more risk. You're really good at managing it, which is why you do it for a living. Individual investors might be less so, and that's something we should pay attention to.
It's true, but it is one of their missions lately, right? Through Reg A and Reg A, Reg CF, all those sorts of crowdfunding things.
Yeah.
Right?
Yeah, it's going great, man. Yeah, we can talk more about that. Oh, seriously, I don't mean to be facetious. What I want to say about this is that we should just like we're at Berkeley, we should be rigorous about it, right? Put more people in this kind of stuff, more people are going to get hurt. It follows. Now, maybe we're prepared to live with that because of freedom, but maybe not, and we should talk about that.
Great. Well, so we've all agreed we don't think shareholder count is right. So let's talk about what other ideas we might have for how to regulate whether a company should be moving to the public markets. Do you want to start?
Oh, I think it's tough. I want to put one thought out for you guys to be aware of, though, because there's a really cool paper that I reread it the other night because I'm preparing for this, that actually shows something that makes more sense to me, and I'm curious what your reaction would be. That actually one of the things that's driven the increase in the size of companies was not so much Jobs Act and 12G and that kind of thing, but instead the 1996 statute, the National Securities Markets Improvement Act, which allowed for larger venture capital funds to be assembled with larger amounts of underlying beneficial owners, not under the 33 and 34 Acts, but under the 40 Act, the Investment Company Act. It just made it easier to put together a big VC fund, and that's consistent with my own experience because those funds are a lot bigger now than they were when I was a market participant. And so one thing I think you'd want to think about is not just the beneficial owners, but you made this point earlier, I think, and you made it very well. What kinds of beneficial owners are we talking about? So do you have a very large underlying sophisticated fund that's got many underlying beneficial owners, et cetera, or not? I would want to start not with a count, but instead an understanding of the kind. One reason that matters to me is that institutional VC type owners are very different kinds of owners that add lots of value I care about as an investor guy. They're on the board. They're really good at guiding companies, not just in terms of the ones they pick, but how they help them to be run. So I think I would start somewhere closer to that.
Focusing on the investors.
Yeah, the underlying type of investor and what I can expect from that investor in terms of protection of other investors. Because when you do the work that you do, making sure a company grows at the right pace and is run well, you don't protect just you. You protect everyone who's invested in the company, and that makes me feel differently about the prospect of it being public, for example.
So you're talking about piggybacking. Thanks.
Well, yeah, sure.
Yeah. We'll come to Theranos in a minute. Any other ideas for how we might decide which companies should be public? I'll throw some out there that have been discussed. So, revenue, capital raised, public float on the private markets, which who knows what that really is, assets, or some combination of all of those things, plus the number or type of investors. Who knows? I don't think anyone really knows what the right answer is, and this is hard. I will know, I learned recently that in the UK, the Companies Act, which is, for all intents and purposes, similar to our Delaware General Corporation Law or whatever state incorporation law you have, actually requires private companies of any size to publicly file their audited financial statements. That was interesting to me. Yeah. I don't think we're going there, and I certainly wouldn't suggest it, but it is interesting and maybe would solve some of the issues that Commissioner Lee is focused on. Any other thoughts on the right metric? If not, we will wrap it up with our last topic. Sorry.
Go ahead.
I would just say that the focus, if the focus is on later stage private companies, the institutional investors are generally the ones that you're negotiating with, right? So, they have a lot of expertise and they have a lot of leverage in some of those situations, and perhaps they aren't doing or fulfilling their duty to their investors, but that's kind of an issue to me between them as opposed to between the company and that institutional investor.
Interesting. Can I have one more thought? So you said revenue, assets, you pointed out the Company Act required. So the idea, I have to tell you, as you described it, the idea just seemed to get worse and worse. Like, man, the government's gonna pick this number and then they have to revisit it over time, right? Because, and also, one thing that's hard about this is that the metric I would choose, that you guys are changing the world like every 15 minutes. Like, I've been up here for half an hour. I'm sure there's like 3 new ways for me to get a pizza. Like, it's unbelievable. So counting employees is, counting assets, counting revenue. It just seems like you guys might move the world in a direction that I can't foresee. So picking that number seems like not a great idea. That's why I was interested, Adam, in your point about understanding the underlying investor base. Not just its number, but its kind.
Right.
And that might be.
But you can have very sophisticated investors who don't do any due diligence.
Theranos, did you say?
Yeah.
Well, we can get to that.
Well,
Yeah.
one thing one argument I hear often out of Washington, the opposite of what you're saying from earlier, is there's this idea or the cynical view of perhaps that most founders are out there to, get money, get liquidity, and take advantage. But most of the founders that I think that I've at least worked with are trying to do what's right by their employee base. They're trying to get them liquidity early. They want to go public. They want to do the right thing. And I think there's going to be these edge cases, of course, where something goes wrong. Sometimes that happens in the public markets too. But for the most part, every founder I've ever worked with really wants to do what's right by the company.
And by that,
I think
you
that's
mean
important.
give them liquidity?
Give them liquidity, do well by the investors. They're trying to do what's kind of right, and they just kind of need guidance to get there.
Plus, there are VCs have lots of power, right, Scott? If you really want your company to go public, you don't really need to try very hard. You're in the boardroom, right?
Yeah, and that's, gets back to the power dynamic of, who's in the room, where's the leverage. And I think your earlier point on, when companies get too big, they can exert a lot of leverage with those IPO negotiations. There's a lot of areas for more attention. I think that, kind of the interesting part of this conversation feels like we're kind of focused on something that feels a little ancillary when there's all this other really good stuff that could be addressed in a lot more surgical way.
Maybe we should just talk about due diligence a little bit and what that looks like. Both Adam and Jen have been through lots of private company financings and certainly through a couple of public company processes. In Adam's case, how does the diligence process differ?
I can't say for the public company stage, but it differs, depending on the investor, right, obviously. I would say, some of the probing questions we get, are much more into things that we would never have to disclose in a public filing. For example, like litigation strategy, how do you handle this? What would be your strategy moving forward? And so I think it really depends on the investor and how sophisticated they are and what they're honing in on. But obviously, if we want them to invest, we're going to be transparent and disclose that information.
Yeah. And I just say, as you could, obviously, something that I said earlier is when you transition to that public market, you are hitting those crossover funds, you're hitting those institutional investors. Mm-hmm. And for the most part, they have a lot of leverage in some of those situations. And maybe, the Facebooks of the world don't succumb to that. But I think, again, the average company size that want a successful IPO, they're trying to get those folks in because they want to start establishing that credibility. So, information request access rights and diligence and meetings with all of the founders and all of that is part of that process.
So what was harder, that or going through the IPO process with the Underwriters Council being a real jerk? That was me.
That was Sarah. They're just, the two experiences are very different to me. One seems just far more process oriented, and another seems like there is kind of more volatility in what may end up happening. The latter being on the private raise versus the former being kind of that process oriented piece.
But I think I'm just thinking about what Commissioner Lee and the more recent SPAC rules are getting into. I think the SEC wants more gatekeepers in the room on all of these financings, right? And that starts with the underwriters, and if underwriters are involved, then of course law firms are involved and required to give opinions. Auditors are giving audit opinions, and I think that's really what she's aiming for. You asked me what I thought she was aiming for, and I think it's that. But I don't know if you think the same thing.
I do. I think one of the things you realize when you're in any regulatory job, and I know you had Noah from the FTC here earlier, you realize that no matter how many people the agency has and no matter how much reach it's got, there there's just absolutely no way that the SEC's actual personnel can do the task of protecting millions of investors subject to trillions of dollars of risk. No, the way those people get protected is by market practices, who are trying to do the right thing, and who are overseen by other people who are trying to do the right thing. So I think I wasn't in the job very long at all before it became clear, look, if you want to protect people, the way to do it is to move the market, to move the practice that somebody will have in a boardroom, that an underwriter's counsel will have, the questions you'll ask, the answers you'll give. That's how you achieve investor protection. I think that is very much what Allison has in mind.
So I'm told we need to wrap up, but we really need to touch on Theranos for a second. I don't think that they would have ever been forced to go public based on number of shareholders. So let's just put that to the side. Anything the SEC could or should have done in Theranos?
Oh, you're asking me? Well, first of all, just to be clear, we did. We sued and settled. At the time, it's public now, I'll tell you, I voted for the settlement. I think it was the right thing to do for investors.
Sorry, caught you off guard with this one.
Well, no, but it's a very fair question. I mean, I watched the HBO, was it HBO? Hulu? No, Hulu, sorry, Hulu. I watched it too. It's an astonishing story, but I think actually, for many people who've been in this fundraising and business community for a long time, it's not that astonishing a story. Because at the end of the day, a lot of this community works on the relationships among investors and the invested, and it strikes me as a totally plausible set of events that happen, very unfortunate and sad events. Could the SEC have done more? Of course, the answer is always yes. But I also think the market could have done more. And to just connect it to your previous question, which I think is a very good one, when I look at a situation like that, I'm not as concerned as I might be about the SEC and its staff. I mean, when the staff realized what was happening, the San Francisco office got engaged and we pursued a settlement that I think made sense. But really what I would have hoped was that the market discipline that this area is so well known for would have gotten to the answer easier and more quickly. But then again, that's very easy to say in hindsight. And I don't want to be the guy who sits here and makes a judgment about decisions people made in a room 4 years ago on the best information they had in front of them. I think that things the SEC can do is send a clear message when something like that happens about what went wrong and what they expect to go differently the next time. And I do think we achieved that with that case.
I agree. All right. Thank you very much. We're at time. We have a little break.